All rise, please. United States District Court is now in session. The Honorable James L. Robart, United States District Judge presiding.
Please be seated. The clerk will call this matter, which will take up most of the morning.
Case C-12-1282, United States of America versus City of Seattle. Counsel, please make your appearances for the record.
Good morning, Your Honor. Mike Diaz for the United States.
Mr. Diaz.
Good morning, Your Honor. Tim McGaff for the United States.
Gaff.
Good morning, Christina Fogg for the United States.
Fogg. Thank you.
Ronald Ward, monitor.
Peter Ehrlichman, monitoring team.
Matthew Barge, monitoring team.
Peter Holmes, Seattle City Attorney, Your Honor. And with me is Rebecca Boatwright, my assistant, who is our lead on this case. Most of the court's inquiry today is probably directed to Brian Maxey, counsel to Chief O'Toole. Chief O'Toole is with us, as is Assistant Chief Robert Murner, who could not be here at the last status conference, Your Honor.
Thank you.
Pierce Murphy, the OPA director, is also in the courtroom. And I'd also like to point that Ian Warner here is here today in a new capacity as counsel to Mayor Murray. At the end of the table, of course, is Ed Lopez, the executive director of the Community Police Commission, and Ann Levinson, our OPA auditor.
Thank you. Well, welcome to everyone. As is the case with all proceedings held in this matter, we are videotaping this. I went looking for the videotape last time and found that it was in Washington, D.C. I'm still not clear why that is, but there is a administrative office of the court's pilot project to allow cameras in the courtroom. And we in the Western District of Washington signed up for that because we are unanimously of the opinion that it's a good idea. After we tape things here, they are then transmitted to the website maintained apparently by the administrative office of the courts. You then need to find the pilot project regarding cameras, and under that find the Western District of Washington, and then under that find the Department of Justice versus the Seattle Police Department. That to some of us seems rather unnecessary, and I have asked the clerk's office if they can to simply post it on the Western District of Washington website. The Ninth Circuit manages to do that, so I'm not sure why we can't. But if any of you are interested in watching the entire proceeding on videotape, as it is right now, it should be up on that site, the administrative office of the court site, probably no later than 10 a.m. or noon tomorrow. That's one housekeeping detail. Ms. Lopez, Judge Levinson, thank you for coming. It was important to me that we get some kind of basic ground rules here, and it seems to me that as the professional aspects of those various functions that you have, it was appropriate to invite you. I asked that we set, or I set, I guess, this hearing or status conference because I'm concerned that we're not approaching the questions, the very serious questions that we have, in the most efficient manner and in a manner that produces the best result. The last hearing, which became much more politicized than it needed to be, was the court explaining the terms of the settlement agreement, which included the fact that the settlement agreement could not be altered except with consent of the court. Anyone who attended their first day of law school knows that's the rule, that court orders can't be changed by the parties, that they can only be changed by the court. Further, the settlement agreement contains a provision that if the parties undertake to change something that relates to the subjects of the settlement agreement, that likewise needs to come back to the court for approval. There was an effort to do something that would have contravened those basic principles, and it was important to me that I stop it and get everyone back on the proper path. So let me begin by saying, why are we here? Well, we're here because I'd like to create some framework for the questions of accountability, review, and discipline that are necessarily interrelated and consequently need to be created and presented to the court for approval in a manner that recognizes they are interrelated. I asked the monitor to give me, for my internal use, a flow chart of the current accountability and review systems. I understand that the parties today are going to present a slightly different version of this, but it graphically portrays into the court the fact that we have at least 3 separate and distinct but interrelated systems operating. I'm looking forward to seeing the flow chart that the parties have prepared to see how many lines linking those 3 independent systems they have. But it does not make sense to me to, for example, adopt a protocol for the early intervention system, which relates back to the use of force board and to complaints of misconduct or discipline, as a freestanding system without figuring out how it relates to those other freestanding systems. And yet that was what the direction that we seem to be headed. So today is going to be devoted to how do we come up with a more integrated and, as always, transparent system by bringing to the court various systems which relate to one another and have been created knowing that those relationships, and that they need to operate in harmony. Let me give one other bit of advice and then I will turn to the parties. There seems to be some ambiguity in regards to the monitor, Mr. Bob's role in this. Mr. Bob is not the court. He's an agent of the court. He provides substantial input into the court's decisions. But I need to make it clear to all of you that the fact that the monitor or the monitoring team knowing of something doesn't mean that it has achieved court approval. I thought that was apparent. If it wasn't apparent, then I apologize for that. Secondly, we need to remember who the parties are in this matter. And the parties are the United States of America, acting through the Department of Justice, and the City of Seattle, and in particular the Seattle Police Department, which are parts of the City of Seattle. Those are the parties. Those are the parties who are here in court and are in charge of coming up with the positions taken by the respective plaintiff and defendant. Who's not a party? Well, that's pretty easy. The CPC and the OPA are not parties. That doesn't mean that they are not of consequence. I have specifically asked their input on the very weighty decisions that we're being asked to make. But to use the vernacular, they're not at the table in the sense of being a party in this litigation. And I think we also need to make that clear. And then I'm going to freelance on some of my remarks because we've got another inflammatory article appearing in The Stranger. I'm not sure when this one was published. The copy I have is dated August 26, 2015, and features a really nice photograph of the chief of police standing between Mayor Murray and some members of the city council, I guess, which once again quotes a bunch of people. Some of them I think may be CPC members who are articulating their belief that there is not sufficient public oversight for the reform process. My reaction to these articles is always the same, which is this is a work in process. We have gotten some policies in place, and they've now actually begun the process of reviewing those to determine how well they're working. But as I want to stress, it's a work in process. There are significant aspects of this which have not been touched. I know, for example, that the Community Police Commission would like a more hands-on role. At least in the litigation that's pending before me, their role is articulated in the settlement agreement, and the court will enforce it until it's changed with court approval. There are lots of other parties who are involved in this. The Office of Police Accountability, the OPA, clearly has a role in this in the form of greater civilian oversight. We have started on those processes. I'm dismayed that the CPC commissioners apparently threatened to resign. I learn now they did so in the summer of 2013. And articles have suggested that they did so after the last time I was out here. I don't find that constructive. I simply think that, we're trying to accommodate a lot of points of view, some of whom are not here very directly. For example, the Seattle Police Officers Guild and the Seattle Officers, I guess more higher ranking officers, Labor Association. They have membership on the CPC, but they also are directly negotiating with the mayor's office on new police contracts. And that's one of the things that is very much on the mind of the court, is the fact that the disciplinary process is an essential part of this overall reform effort. And I'm troubled that there seems to be the notion that we can just charge off and do something without understanding that we've got a lot of moving pieces and they all need to mesh together. There's a statement in this particular article saying that the court approved something. I certainly signed some early intervention system policies that had gone through the entire process of review and I'm now told that there was unhappiness with them. It's my practice not to approve those policies until I've had a thorough opportunity to review them and receive comment. If there's no comment that comes in, then I don't consider myself very accountable for not being aware of it. So, by my chart, we have the early intervention system, which operates inside the department and ultimately ends up with a decision that apparently is made by the bureau chief. I think it's important in regards to that system that we recognize that it is not a disciplinary system. It is a system that was followed in a number of other jurisdictions, districts, which have settlement agreements or consent decrees, and it's a way that we can early on find people who are having trouble or people who are choosing to ignore the way that the department is to operate. It more or less independently exists. However, it receives input from the Use of Force Board and from the complaint process, which involves the Office of Police Accountability. So it rather sits out there on its own, but really doesn't sit out there on its own, but it belongs to the police. Then we have the Use of Force Review Board. It starts off inside the department and has a referral function back to the OPA. It is, by its definition, responsible for policy and training suggestions. But because it is related to these other entities, it has a relationship to them. And finally, we have the misconduct aspect of this, and I will choose to confuse external complaints that come in and internal complaints. Those go through a process of some internal review by the police and a more thorough review by the Office of Police Accountability, which includes an executive director and an auditor. It has investigative power. It makes recommendations. Those recommendations go to Chief O'Toole, and there follows then a whole series of options that involve union grievances, employee actions, arbitration, discipline review board, and public safety civil service commission. That's why I'm saying that there are a lot of moving parts that need to mesh together, and I don't feel that we are doing that very well at the present time. So let me start with the Department of Justice. Tell me how we do this better.
May it please the Court, Your Honor. As we just heard, Your Honor called this hearing to discuss a harmonious, integrated, and efficient and effective approach to meshing all those mechanisms and systems created as part of this Court's consent decree. And we think that's an appropriate discussion to have at this time. What we wanted to do first off, take a few minutes, is to provide some context on how we got here, where we are today, and where we are today in the development of those mechanisms and the reform process. In other words, Your Honor, we want to explain our approach to reform as set out in the consent decree, which the DOJ and the city have agreed upon and the court has ordered to be effective in this, in this district. The city can then talk a little bit more specifically about how those mechanisms and others are actually working in practice right now, so you can get a better sense of how those different flowcharts you're looking at actually work in practice from its perspective. So if you'll indulge me just a little bit, At the highest and most abstract level, what are the goals of the consent decree? And I've set them up here on this PowerPoint. These come from the first sentence of the first paragraph of the consent decree and has been cited by this court in prior hearings. This is what DOJ calls, not just here but in other places, the three-legged stool of reform. What we want, ultimately, what our goal is policing that complies with the requirements of the Constitution while allowing police to be effective, i.e. keep doing their part to keep residents of Seattle and themselves safe. 3, all in a way that the residents of Seattle can have confidence in. Today's hearing is really focused on the first leg of that stool, how DOJ tries to ensure constitutional policing. But from our goal-oriented perspective, it cannot be detached from public and officer safety and the community perception of both. So how do we get at what's DOJ's theory here, or the approach to reform as to the first goal? Well, following negotiations in 2012, we established an approach to reform which we at DOJ have been calling the 4 pillars of reform. This approach of reform arose from nearly 20 years of enforcing the federal law, giving DOJ pattern or practice jurisdiction and this court jurisdiction over this matter. It came from 20 years of learning from previous consent decrees around the country and trying to improve our efforts at institutional reform. The 4 pillars there up on the chart are developing clear rules of the road for officers and so that the community itself can know what to expect from its officers. Then training to those policies consistent with the values of the local community. 3, setting up the systems or mechanisms of supervision and accountability that have sufficient fail-safes or redundancies. Not redundant, but redundancies, to use the engineering term, that even if one part fails, the entire structure will continue to stand and operate. That's the focus here today, is Pillar 3. And finally, though, Pillar 4 is the assessments, testing the system to see if it's working in practice. Not by anecdote, not by hunch, but by actual rigorous tests. So for us, what's important about this, and then I'll turn to the pillars, the pillar number 3 in particular. What's important for us is when these 4 pillars are in place and are working, the structure is sound, and DOJ can have confidence that constitutional policing is self-sustainable and ingrained in the police department. Very quickly, before I turn to the 3rd pillar, we know where we are on the first one. We've gone through the first iteration of policies, and we've completed, for the most part, the review of those policies, as we discussed last hearing. That process is undergoes a continual process of self-correction. Second pillar, we are now well into the 2nd year of training, and the court's docket, which is public and transparent, is replete with examples of what is being trained at SPD, day in and day out. It's a measure of transparency that's really remarkable, Your Honor. And so far, we have dozens of examples. Every weekend, after every weekend, we get examples of police interactions to demonstrate how that training has made a difference. So, though, turning to the 3rd pillar, and these are highlighted in red are some of the things that you've talked about there, Your Honor. The systems and mechanisms of supervision and accountability. And the way we've been thinking about it, Your Honor, if this is helpful, is there are some of these that are reactive and some of these are proactive. And that's an important, and some of them are both. But those are important distinctions, way to think about this. So one example that Your Honor didn't discuss in his opening remarks was the Forced Investigation Team, FIT, the first red there. FIT is a specialized unit of highly trained investigators which sit outside of the chain of command of the officer who used force. It rolls to the scene of the highest levels of use of force, including officer-involved shootings, and conducts a thorough and credible investigation. This allows the department and its community to find out what really happened in the force incident, and to allow supervisors to hold officers accountable and learn from the event as they occur. Another example of this is an example of a proactive system, as Your Honor discussed, so I won't go into too much detail, is the Early Intervention System, EIS. It is a computerized system that identifies markers of potentially problematic behavior before they become actual problematic behavior. For example, auto accidents sometimes can be seen as a sign of stress, or they may not be. It could just be bad luck. But if a certain threshold is met, EIS will notify the department to take a holistic look at the officer's conduct and see if there's an issue there. Another example is civilian complaints. Again, EIS will notify the department to take a look and see if there's an issue there or not. Similarly, while FIT the FIT team might look at the particular force incident. EIS will allow the department to identify possible trends from multiple, maybe even likely appropriate uses of force before issues arise. Finally, as an example and the last example I want to talk about here is the Force Review Board. As Your Honor discussed a little bit, this is an interdisciplinary body of officers and supervisors that both reviews intermediate and high-level uses of force, yes, for policy violations, but also for trends to improve policy and training, and even equipment issues that could affect force events in the future. So in that sense, yes, it's looking backwards to what already happened, but it's also looking forward to trying to improve the department actively. And what's important here, Your Honor, before I dig in a little bit into how these systems interact, what's important, these have all been used in other cities. In the 20 years of DOJ work in this area, they've been shown to work. So how do they work together? Here's a very basic schematic that we have. The city is going to expand on this a lot more in its presentation, how it works in Seattle. But from the DOJ approach to reform perspective, here's an example. A significant use of force incident, a type 3, for example, a broken bone, an officer-involved shooting, something that's quite serious. Everything in red is new or significantly expanded under the consent decree, under this court's watch. First off, if you see to the right of the oval, this type 3 force and all reportable force are logged into EIS. So now the data is being captured. And then a supervisor is called out to the scene, there to stabilize the scene. Because it's the type 3, the force investigation team rolls and conducts the thorough and objective, credible investigation that the department itself and the community deserves. That investigation then, as you go down, will be presented to the Force Review Board. It debates the case and issues findings. And, importantly, for transparency purposes, it issues bi-yearly reports to see how things are going, what lessons they've learned, how they've improved. At any point in this chain, literally any point, from the moment it happens, through the supervisor to FIT, to the Force Review Board, officers on the scene, anybody can refer it to OPA. And of course, members of the public, including the subject of the force, can refer to the OPA. This adds another layer of transparency and community trust. So finally, those are the first 3 pillars of DOJ reform. So Pillar 4, what does Pillar 4 do? That is our approach to determine whether or not it's working and working properly. This is not a check the box process. This is where we are seeing whether we're getting to the root of the issues and whether it will be self-sustainable and ingrained in the police department. And so very quickly, what you can see of the 15 assessments coming down the line, which we talked about the last hearing, you can see the different roles the different entities play. You have the monitor proposing a methodology on how to evaluate a particular system. How do you know if a Force Review Board is doing a good job? How do you know if FIT is doing a thorough investigation? And that methodology the parties can comment on and ultimately agree to an approach, which has been successful so far. SPD pulls the relevant data, and then DOJ and the monitoring team independently review with their own subject matter experts the data that's been provided by SPD. Then the parties and the monitor confer on their independent findings. The monitor writes a report, which is filed publicly on this court's docket, and then the parties decide whether or not they are in agreement with that report, on whether or not there's compliance on this particular issue. Ultimately, though, it's Your Honor that decides whether there's compliance, taking into consideration the parties' filings and the monitor's recommendation. And they have to hold that, as you can see, for 2 years in order to be found to be full and effectively in compliance. So in conclusion, Your Honor, with all of that as background, and I know that's a very high level, but that's DOJ's approach to reform, not just here, but in other places. Ultimately, there's a significant amount of experience in informing the DOJ's approach to reform, and that is baked into this consent decree here in Seattle. Significant progress has been made by the city on the systems. And it's a good time to look at this holistically now as we embark now on the 15 assessments between now and March 2016. So with all of that as background, Your Honor, we're prepared. We're going to hear the city's presentation, and we're prepared to participate in discussions of the matters that you sent out in your docket entry and to explain a little bit further here today.
All right.
Thank you, Your Honor.
Mr. Holmes or Ms. Birthright? Ah, Mr. Maxey.
Yes, Your Honor. So, Your Honor, what I'm hoping to do here today is to expand upon that flow chart and the concepts that you were presented with and try to tie all of the accountability systems together into a coherent picture. And to assist with that, we've created a model that is imperfect, as there are certainly different loops and feedbacks and other possible lines that could be drawn on this, but this was the most coherent way that we could figure out how to present. And I do apologize for the colors. I promise you this is actually a very beautiful graphic. On the screen it's a little bit dark, so I'll help to walk through this.
There's a brightness contrast you might want to experiment with.
So let me start here, expanding this triangle a little bit here.
How about if we tilt it so that we can read it?
Well, I'm trying to direct your attention to the column on the left that really are the substantive matters that the department monitors, grapples with, and deals with. We have serious policy violations. We have significant Type 3 uses of force, which, as Mr. Diaz suggested, are the officer-involved shootings, the higher levels of force. We have the Type 2 uses of force, which are intermediate levels of force, one that cause injury, complaint of injury, or reasonably likely to cause injury. That would include taser applications, other less lethal pepper spray, beanbag shotguns, and the like. The Force 1, the lowest level of force that still remains reportable, and that's really the transient pain, usually from handcuffing or the active pointing of a firearm, are our most common Type 1 uses of force. Other things that the department monitors certainly are lawsuits that are coming in. I'm happy to report that this year there are very few. I think we're ranging somewhere between 6 and 8 suits filed in 2015. We look at collisions, we look at pursuits, we look at minor policy violations. We're concerned with officers' attendance at mandatory trainings, and we track that independently. We track every stop and detention now. This is something that's new under the consent decree. The Terry template went into effect, I believe it was in mid-May, May 15th. In the first 45 days of that new template, gathering the data on who officers are stopping and what the reasons for those stops were, we made 1,600 stops, which I think is an excellent number. It's very reassuring to have the data that officers are out there proactively engaging, and we were able to review the reasons for the stops, and it does appear that officers are reporting Terry stops appropriately, and from what we can tell are actually over-reporting things that actually would be citations or other forms of police contacts. And then we have on-scene bias investigations. This again is new under the consent decree, the bias investigation. If there is even the implication on scene of that a stop was biased or a contact was biased, the officers are required to call a supervisor to the scene and have that supervisor do an investigation. If the person does not wish to stay, and certainly the officer is not going to detain the person in order to do that investigation, the individual is provided with the contact information for both the Office of Professional Accountability and for the officer's supervisor. And there's an on-scene investigation. If that investigation determines that, in fact, there was the possibility of bias in that interaction, it is then referred directly to the Office of Professional Accountability for further investigation. Take us back up right here. Yes, Your Honor, if you would prefer, I can also pass up a paper copy of that, if this would be
No,
helpful.
this is fine.
Okay. So what we have here,
bottom tier there are the substantive areas, the department monitors. The first 9 on the left all plug directly into the early intervention system, and I really appreciate the court's comments on the EIS system. It is non-disciplinary, and it really is there to allow management, first line supervisors to contact officers and vet if there are any systemic problems that are going on. So all of those inputs are triggers for the early intervention system, and a variety of combinations of lawsuits or force or pursuits, or one that I left off the chart, canine bite ratio, factors into whether there would be a trigger within the EIS system such that the supervisor should consider doing a mentoring plan and figuring out a path forward for that officer. All of those mentoring plans, if they are put in place, or in fact if they are declined and no action is necessary, is reviewed by the Performance Review Committee. That is a committee of SPD personnel that review not substantively, but attempt to ensure that supervisors across the department are providing systematic and consistent and fair mentoring plans, and that we don't have an overzealous sergeant in one precinct or an underzealous one in another to ensure the operations. Similarly, the black band there, the chain of command, it has immediate review over the majority of these systems. Only Type 3 force and serious policy violations do not go through the chain of command. Every other input goes through that. And what that really does is it empowers the first line supervisors to know what's going on with their staff and to vet and approve or disapprove any of these actions that their officers take.
When you say a first-line supervisor, you're referring to a sergeant?
I am talking about a sergeant. Depending on the system, it then gets reviewed up by a lieutenant and ultimately a captain, and the majority of those inputs go all the way through the captain. If at any point, whether it's that sergeant, the lieutenant, or the captain, sees that there is potential misconduct in the action of their officer, they are mandated to refer up into the Office of Professional Accountability, which on this screen right now is sort of that amorphous, it looks sort of purplish to me on the pretty graphic, it's red. And this is where OPA comes in, and OPA does the systematic review of the case, full investigation, coming to either sustain, not sustain, a variety of findings, which then is reviewed after the completion of the investigation by the OPA auditor. The recommendations occur after the certification by the auditor, and that information is sent up for the chief to actually make a disciplinary decision on that recommendation from OPA. Ultimately, of course, the chief is accountable to the mayor for the decision she makes in the course of managing the department. The mayor, however, is not directly involved in the discipline or accountability systems. In the center of the graph here, right in this area, are a bunch of review boards. And these review boards have different functions. I think the most significant that's come out of the consent decree is if you track up here with the Type 3 uses of force. You have a Type 3 significant use of force. It hits the early intervention system. Certainly it goes to the Performance Review Committee. But immediately goes to the Force Investigations Team, which is a specialized call-out unit that will go to the scene, do an investigation, do interviews that very evening of the involved officers in a Type 3, and try to as thoroughly investigate and provide a recommendation into what's very difficult to see here is the Force Review Unit and then the Force Review Board, which is right above the Force Review Unit. The FIT cases, again the most serious, bypass the chain of command because we want to ensure that there's an independent, thorough, and objective investigation. And it feeds straight into the Force Review Board. Even though the Force Review Unit will look at those cases, they're not making any decisions about which of those most serious cases should go to the board. all of them go to the board. And the board considers it not just for was the force objectively reasonable, necessary, and proportional, but any training implications, any equipment implications, any policy implications. And those are the feedback loops that I was unable to put into the graphic, which feed back into training, back into policy, back to the chain of command, depending on what the board's recommendations are. Similarly, on type 2 uses of force, the new use of force policy that Your Honor just approved now has all the type 2 uses of force going into the force review unit. This unit does an administrative screening on all cases, decides which cases are significant enough or have some issue that should be considered by the board, and that is passed on. That is a thorough review. It happens at the detective, sergeant, lieutenant, and captain level, and that's the same captain that sits on the force review board and chairs it. In addition to those cases that the unit flags for going on to the force review board, there's also a random 10% of all cases that are sent on to the board just for quality control to ensure that the unit is doing its job appropriately. You know, the other boards that are depicted here, we have the collision review board that reviews all collisions and finds out whether they were preventable, non-preventable. If there's any semblance of misconduct, it goes on to the Office of Professional Accountability and up the chain to the chief. Type 1 uses of force are screened by the force review unit and are do not go before the board. They have a much more limited review as they're more numerous. Again, pointing of firearm and tight handcuffing tend to be the bulk of those. This new use of force policy that Your Honor approved and the implementation of this force review unit, I'm happy to say that we've been able to catch up on the backlog of force cases, and I believe we are now only 20 cases behind, which should resolve itself in the next month or two. So we've made great progress in ensuring that every use of force is timely and consistently reviewed. Another centerpiece of the consent decree and the reforms that are going in place really is the data gathering element, and I know the department is working very hard at moving the data analytics platform forward so that we've got an easy systemic review of data. But during the interim, until that system is fully online, and as the monitor's assessments are going forward, the department is critically analyzing all of the data that's available to it. We have a data-driven policing unit that has been beefed up significantly. We have PhD-level analysts that are reviewing our data to see what we can discern from it, which feeds back into operations, into policy, and into training. One thing I wanted to highlight for the court is that, again, on May 15th, we put the mental health contact form requirement, and it went online in Versaterm. This means any time an officer contacts someone they believe is in crisis or has mental health issues, they fill out a form that identifies that person, what happened, what action was taken. In the first 45 days, we had over 1,900 mental health contacts, again showing the proactivity, but also the very concerning prevalence of people in crisis in our city. Within those 1,900 cases, there were only 4 uses of force at type 2, and there were, I think, 39 at type 1, almost all of which, again, were tight handcuffing, which is expected when someone's in crisis and pushing against handcuffs. So I think that's a remarkably low use of force, and for the department, it is encouraging to actually have the data to be able to stand up and say that. So what I hope I'm presenting here is that from the departmental perspective, we have a bunch of systems. They are interlaced, they are working together, they're complementary, and we think it's a pretty coherent approach to accountability within the department. Looking at that OPA and OPA auditor band, I mean, that is sort of at the heart of the accountability reforms that the city has recently presented to the monitoring team. And the development of those recommendations, they started back in 2014 when the CPC and the OPA auditor, consistent with their obligations under the MOU, started to have conversations with the rest of the city to take a look at the accountability system, see what was working, what was not working. And over 2014, there were a variety of dialogues. A lot of time and energy was spent trying to figure out what was working and what was not. This all came into a head this year on Pride Sunday when there was a summit meeting of people from the mayor's office, from SPD, from the CPC, OPA auditor, all met and worked late into the night, really trying to come to a consensus document on this. And I do realize the city is a many-headed hydra, and there are many people that purport to speak on behalf of it. But I do wish to assure the court that it was always the city's intent to provide whatever these recommendations were to the monitor and ultimately to the court. Certainly the city is very cognizant of the court's role in this and that nothing may occur without the court's approval ultimately. So at this point, what's been presented to the monitor for review, discussion between the parties, and ultimately, should we be able to come to some form of path forward and a consensus ultimately to be presented to Your Honor, really is a reform effort for that one band up there, the OPA and the OPA auditor roles. That's really at the core of it. And the initial legislation that created these accountability systems have evolved over time by MOUs, by court cases, by arbitration decisions, and ultimately what's happening in practice is not really codified in the original ordinance. So much of what is proposed by those recommendations is bringing the current status quo and codifying it in a way that reflects reality. But there are also several really important expansions that are proposed in those recommendations that we look forward to discussing. And I think probably the most significant from the department's perspective is that we've created all of these new review systems and all of these new accountability systems and they're new. They're all part of the consent decree. And right now the monitor's looking at it, the court's looking at it, certainly DOJ with its independent obligations is looking at it. Ultimately, the city will need to be able to move forward and self-assess those accountability systems and make sure they're working. So the primary expansion is that OPA would have more of an auditing role over all of these systems and transparency into the department as a whole. Similarly, the OPA auditor's role would be expanded to watch what OPA is doing and ensuring that it's meeting its obligations under that. And then finally was in the recommendations is the proposed role of the CPC as mainly an advisory board to the department and development of policy and to OPA and the OPA auditor on their functioning. Again, I think the main goal here was to take the current practices, make sure that they are codified, and give greater transparency and community input into our accountability systems.
All right.
Do you have any other questions? Thank you, Your Honor.
Mr. Diaz, do you want to say anything further?
We do not, Your Honor, have this time.
I was provided by the monitor, who received it very recently, a copy of the City of Seattle's submission regarding accountability in civilian oversight recommendations. I've not had an opportunity to review it. And secondly, it seems to me that at least some of the items in it are more internal to the city and may well be outside the scope of the settlement agreement that was reached. So I'm not going to make any comment on it other than I am happy to see that there seems to be an effort to get down on paper some of the implicit policies and frameworks which are behind this process. So thank you for the parties for doing that. I am, in an effort to move this matter forward, going to ask the following. By September 30, I would like the Department of Justice and the city to file jointly or separately an approach for the existence of accountability and review systems. And I would like that to be not extensively detailed, but something that will assist the court in its evaluation of what I do on a more regular basis, which is to review the policies that you are submitting. For example, I see a wide range of views as to the early intervention system, and until we can come up to some common definition of what the early intervention system is and its purpose, it's hard for me to implement those particular policies. This does not need to be a giant notebook. It just needs to be a statement of what are seen as the various systems that are used for accountability and review. As part of that, I would like a discussion of the disciplinary system. It strikes me that the disciplinary system exists and is to some extent outside the control of the court because it's a matter of labor negotiations. But it also strikes me that much of the public controversy that's been generated in this has come from the fact that there have been actions in the police disciplinary system that have been perceived as anywhere from misguided to a violation of the public trust. So I would like to have those. Once I have those submissions, which are to be publicly filed, the court will work with the monitor on an evaluation of that framework. That discussion will serve as in effect, a management framework against which I'm going to be able to evaluate the further policies that are being submitted. The reason that I'm asking that it be publicly filed is that I specifically would like the OPA and the CPC to comment on it. Mr. Maxam, I'm acutely aware of the fact that there's the City of Seattle, there's the mayor, there's the City Council, there's the OPA, there's the Seattle Police Department, there are 2 unions, all of which have theoretically participation in the creation of the City of Seattle's policies. The reason that I'm asking for comment from the OPA and the CPC is that my reading of the settlement agreement is that it asks for transparency so the public is aware of what we're doing. And secondly, that it allows for a mechanism for public comment on what we're doing. And I take that comment seriously. And I have found for example, the suggestions of the CPC made in our last discussion of policies to be thoughtful and helpful. So by October 16, I would like those comments delivered, and I will review them as part of the evaluation process that the monitor and I are engaged in. As I've said, my purpose in this is to use the results of this effort to create a better framework for the independent review of the various policies and creation of organizations that will monitor the performance of the Seattle Police Department. I am aware, because I have looked at the settlement agreements and the consent judgments in various other cities, that there is not one master agreement that works everywhere. I am led to believe that work that has been done in Seattle has been viewed as good and has been exported to other locations. It's important to me that that process continue. The role of the court is not to tell the city of Seattle how to run its police department. There are various models ranging from full civilian oversight to hybrid civilian oversight to no civilian oversight. And ultimately that's a decision that the public makes through its elections and that the elected officials make through their decisions. My role is to look at those processes and ensure that they meet those three levels of public scrutiny and constitutional performance that the Department of Justice opened its presentation with. In the meantime, I would plead with all of you to work together and recognize that engaging in activities which may promote your particular point of view without being collaborative to other folks who have points of view doesn't help me and doesn't move this process forward. Mr. Diaz, anything further from the Department of Justice?
Thank you very much, Your Honor.
All right. Anything further from the city? Mr. Holmes?
Thank you.
My thanks, as always, to the monitor and the assistant monitors. I don't think the public realizes that this has turned into a pro bono activity largely for them. Having coming from a background in private practice, I can tell you that we were strongly supportive of pro bono, except when it occupied the majority of a lawyer's time. We were still required to do other things. So, gentlemen, I know that it's a lot of work, and I appreciate you doing it. And I know for the members of the monitor staff that they work a lot more than they get paid for. We will be in recess, and I will look forward to receiving your submissions.
All rise, please. Court is in recess.